Hello, I am Cecilia Bailliet from the Faculty of Law at the University of Oslo in Norway. I'm presenting my book, The Construction of the Customary Law of Peace, Latin America, and the Inter-American Court of Human Rights. This book was the result of a most auspicious sabbatical year at the University for Peace in Costa Rica, and my interest in the topic resulted from the emergence of new normative iterations of peace at the international level. Specifically, the UN Declaration on the Right to Peace, which all Latin American countries voted in favor of, and the Sustainable Development Goal number 16 on peaceful institutions. So I commenced the book suggesting that peace is a Grundnorm, which has received universal recognition both as an end and a means of the legal system, as one can only attain peace through pacific means of dispute resolution, as set forth in the UN Charter and other international instruments. As it is a Grundnorm, states shall ensure that their laws, practices, and policies harmonize with the aim of peace and interpret it in accordance with human rights instruments, and this would form a type of pro homine peace. So when we think about peace, it is a concept composed of negative peace, the absence of violence, and this promoted the notion of a perpetual peace by Kant, in which republics willingly renounced the use of war. And Kelsen actually suggested that only negative peace could be considered law through the prohibition on the use of force. But this was followed by Johan Galtung's proposal that this is insufficient, that if we actually think about how we arrive at peace, the absence of violence is not enough, that we actually have to think of a concept that he coined, positive peace. And this is actually the conception of the elimination of structural violence through the guarantee of equality to all people, the guarantee of non-discrimination, and the pursuit of cooperation. But Kenneth Galtung, he criticized Galtung for saying that positive peace he felt was a metaphor and couldn't be implemented. So I took this challenge to look at the situation in Latin America and assess whether it's possible to show that positive peace is law and that it can be handled by courts and can be considered justiciable. So when I spoke with the lawyers at the Inter-American Court of Human Rights, they told me that it was important to describe the context of Latin America when discussing peace. Now, Latin America has been characterized by a period called the Long Peace. This refers to the restraint on the use of force between the states in the region. So even though Latin America has been largely successful adhering to negative peace, the challenge of peace within Latin America is because of the failure to implement positive peace strategies to correct the gross inequality and discrimination that is at the formation of internal violence by criminal gangs and paramilitary groups, the immense levels of corruption, the tendency towards elected authoritarianism, the impact of economic downturn, and the consequences of migration that we see in the region. So it's estimated that within Latin America, the richest 10% of the population control 54% of the national income. And this is related to the hierarchical structures that are linked to commodity dependence economies. This means the fossil fuels, the mining, and the agriculture. And these industries and areas, they exploit and marginalize racial minorities, indigenous people, women, and youth. So the region is actually marked by persistent cycles of protests, social unrest that is met by state repression, upholding an oppressive state of what Mark Leonard would call unpeace. Moreover, there's a significant increase of attacks on human rights defenders and those who protest corruption and impunity or call for environmental protection and social justice. So the current war in the Ukraine and its long-reaching negative economic consequences has only underscored the imperative of peace and creates a parallel for one of the focal points in the book, which recalls that there was an Inter-American Conference on the maintenance of peace that was held in Buenos Aires in 1936. And it was organized by Carlos Saavedra Lamas, the Nobel Peace Prize winner, who helped bring about peace after the Chaco War between Paraguay, which was supported by the Shell Oil Company, and Bolivia, supported by Standard Oil. President Franklin Roosevelt invited the heads of state of all the Americas to participate in the first joint presidential radio broadcast in the region. And they wanted to promote mechanisms to pursue regional peace and avoid the catastrophe of war that was plaguing Europe at the time. And this is because Italy at the time had just occupied Ethiopia. So the Declaration of Principles for Inter-American Solidarity and Cooperation was adopted, which set forth the prescription of territorial conquest, the condemnation of intervention in internal and external affairs of another nation, the illegality of the forcible collection of pecuniary debts, and this is incorporating the Drago Doctrine, and also the obligation to pursue dispute resolution via conciliation, arbitration, or international justice. And this is then followed up by a series of instruments, including the Declaration of Lima, the Rio Treaty, and the Pact of Bogota, which recognized the compulsory jurisdiction of the ICJ. But it's notable because the ICJ is examining various territorial disputes related to oil and natural gas exploration at sea. So the states in the region are actually showing some resistance to this form of dispute resolution, and this indicates a possible increased risk of militarization at the maritime borders and potential violation of the long peace. For example, Guyana and Venezuela are competing for the Starbrook Bloc, and Venezuela does not recognize the jurisdiction of the ICJ in this case. Now, the Treaty of Bogota was ironically denounced by Colombia, which prefers negotiations with Nicaragua after the ICJ ruled that Colombia had violated Nicaragua's sovereign rights and jurisdiction in the maritime zone. And one may also consider that this year we are celebrating the 40th anniversary of the Malvinas-Falklands War, which remains contentious as Argentina is calling for a recovery and the UK will not negotiate. And this is in spite of the fact that oil companies have set up installations in the Sea Lion oil field. So we can't take the long peace for granted as tensions are rising regarding access to the offshore natural resources. But nevertheless, the OAS Charter created an architectural foundation for the enjoyment of both negative and positive peace, as it condemns the wars of aggression, it prohibits intervention, it calls for the use of peaceful procedures for dispute resolution and respect for treaties, but it also points out that social justice and social security are the basis of peace, and they call for peace education. Hence, you have a foundation for both negative and positive peace within the region. Now, the next part of the book identifies a typology for peace iterations within Latin American constitutions, and these are pluralistic, a true tapestry of variations that take either negative or positive peace orientations, and they reflect the historical context of nations within the region, and they provide evidence of the flexibility of peace. But the majority of constitutions are what we would call internally oriented statist liberal expressions of peace, where peace becomes a condition for the enjoyment of your liberal right, your right of association, your right of speech, assembly, and petition, and in Mexico, writing. All of them have to be peaceful. And this reflects the concern during the consolidation of the independence period that the new governments in the Americas had to retain social order and control. And this orientation remains the same to this day. At the time of writing this book in 2019, absolutely every one of the Latin American countries was undergoing significant social protests. Now, the Inter-American Court of Human Rights has responded to the repressive tactics of the state through provisional orders that are seeking to protect the lives and physical integrity of human rights defenders, indigenous community representatives, journalists and judges, and political opponents. So this is the court's first level of protection of peace by trying to break the cycle of exclusion, protest, and repression that is the consequence of the region's failure to implement positive peace. Another group of constitutions has externally oriented negative peace, calling for peaceful coexistence and the peaceful settlement of disputes. And these relate also to other constitutions which call for the direct renunciation of war, and the prohibition of nuclear weapons. So we have seen the establishment of sub-regional peace zones and nuclear-free zones within the region of Latin America and the Caribbean. But this is also under pressure because states have been transgressing the peace zones with nuclear weapons through passage at sea, or they could be using nuclear power subs that are armed with conventional weapons. So we know that several Latin American countries have ratified the Treaty on the Prohibition of Nuclear Weapons, but Brazil and Argentina haven't. So there again, we have a possible problem in relation to negative peace. Now, in terms of recognition of peace as a justiciable right or duty, I found a few examples from Bolivia, Colombia, Haiti, Ecuador, Venezuela, and Guatemala. And the country that has the most amount of jurisprudence on peace is obviously Colombia, because its constitution from 1991 is actually called the Peace Constitution. So peace is in the preamble in Articles 2, 3, and 22, and it's characterized as being both a right and a duty of the state and of society. And the judges in Colombia explain the scope of the right of peace as an aim and as a procedure, demonstrating that peace is indeed capable of being justiciable. But Costa Rica, the country without an army, provided a very interesting case because they had a law student who was very concerned because the government had a website where it expressed support for the United States during the invasion of Iraq, and the law student decided that this was illegal according to the Constitution and international law. So he brought the case, and the courts agreed with this law student and ordered the executive to take down the website. But I think that the most valuable part of peace at the normative level is its flexibility, because it can also be applied in a programmatic approach instead of using the courts. So we have many programs that are promoted through civil society and government ministries under the umbrella of what we call culture of peace programs. And these promote peace education, alternative dispute resolution, and cooperation. So Peru has a law on the culture of peace education, which requires all schools to teach peace and non-discrimination and equality. And UNESCO has been supporting culture of peace youth programs throughout the region. And ADR, alternative dispute resolution, is used in many labor conflicts, but to this day, Latin America remains the most violent region in the world for workers. Hence, the Inter-American Court of Human Rights has recognized standing for trade unions to present claims themselves. Now, this section on constitutional approaches to peace is followed by a presentation of the views of former and current judges of the Inter-American Court of Human Rights, all of whom agree that peace is a value of international law, but the scope of peace can vary. So former judges have identified peace as a right and duty, as jus cogens, because it's the corollary to the prohibition on the use of force, as a collective right applying to peoples, indigenous peoples, people who are facing the threat of displacement, and the right to be free from the fear of nuclear tests. Concretely, the Inter-American Court has referred to the right to peace in ober dictum in the advisory opinion on environment and human rights, noting that persons displaced by environmental damage may have conflicts when they flee and meet other communities, and this would then violate their right to peace. However, the court has divisions regarding the justiciability of second and third generation rights, and this is relevant to peace. Now, neither the American Convention on Human Rights and the American Declaration on Human Rights make explicit mention of the right to peace. They also don't mention the other socioeconomic rights. The convention is largely oriented towards civil and political rights, whereas the Declaration has a bit more. And you have the San Salvador Protocol that addresses socioeconomic rights. But positive peace is composed of equal protection and non-discrimination, and these are contained in Articles 24 and 1. And so I found a lot of case law in which the court had declared non-discrimination to have jus cogens status in its advisory opinion on the rights of undocumented migrants, and then developed a jurisprudence tackling concretely structural violence and discrimination, inequality and exclusion, in many cases regarding access to land for indigenous people, regarding the rights of minorities, children, the disabled, the elderly, LGBT rights, access to HIV medication, the elimination of poverty, and the protection of refugees. And Judge Farrar-McGregor set forth a notion of exceptional due diligence due to vulnerable people and the phenomenon of intersectional vulnerability, including poverty, marginalization, and exclusion. So all of this case law is significant because it directly counters Kenneth Boulding's concern that Galtung's concept of positive peace is only a metaphor and not capable of implementation. The court shows that it is concretely capable of implementation. And these cases then were linked to the issue of gender. When I spoke to Judge Elizabeth Odio Benito, she indicated that the woman is the heart of peace, and the Inter-American Court of Human Rights protects women and children. Hence, the court protects peace. So it's notable that within the region, Latin America has almost a complete ratification rate. All 32 countries have ratified the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women. But Latin America also has the highest rate of sexual violence against women in the world, so we have a disconnect between the ratification of law and the actual practice. There is a state of impunity, and we need the adoption of what we would call a sustainable gendered peace that would support equality and non-discrimination, reduce poverty, and eliminate exclusion of women from politics, and guarantee them health, sexual, and reproductive health care. But most importantly, give them procedures, give them access to justice so they can present their claims, and address the accountability, not of the state, but also the very real fact that it's often non-state actors violating their rights. So when I was looking at the case law in this area, there was a mirroring of the division of opinions between the majority that supported protection of women and LGBT rights and the minority judges that were concerned that things having to do with family rights would actually be more adequately addressed at the national level. And this mirrored the polarization in society because we had many protests either in favor of expanding gender rights, be it abortion or same-sex marriage, and counter mobilizations by conservative political groups that were seeking a more traditional approach to these issues. So you had the filing of actual briefs to the court from both sides, and the decisions within the jurisprudence reflect those divisions. And the genuine commitment to positive peace within Latin America, then I suggest, is that the actual key to diminish inequality and discrimination, and the key to keeping the region free from reiterating the same cycles of exclusion, protests, and repression. The key contribution of the court is not only the provisional orders, but also its provision of non-repetition guarantees that seek to concretely correct the structural violence directed at women and other minorities. So I looked at the non-repetition cases, and I found that the parts of the non-repetition guarantees that were not complied with, in other words, a negative finding, these were not complied with, were the ones that actually had to do with training police or border guards or military or judges or doctors in non-discrimination, inequality, because many of the cases had to do with discrimination that women and other minorities had met when interacting with border guards or judges or doctors. And it was very interesting that these decisions then were not complied with, because the training and the education of civil society should be something that shouldn't actually be very problematic. but it involves a programmatic commitment. That means that you're not necessarily going through the Ministry of Justice or the Ministry of Foreign Affairs, which you usually do for compliance issues, that you are pursuing a broader-based, socially oriented, local level peace building a programmatic approach. And this, I think, indicates that we are in a new age of lawmaking where the interface between the court and society is one that is taking a more creative angle and requires a renewed commitment in order to bring about an epic of peace in the region.